So, good afternoon, everyone. I hope I am audible and my visuals are also clear. So, how many people have joined so far? How many people have joined so far? I would request all the students to join in so that we can begin the discussions. Okay. I hope my Okay, good afternoon. Good afternoon, everyone. Thank you for telling me that my audio and visuals are clear. So let us discuss today's topic, the Prohibition of Child Marriage Amendment Bill 2021. Like somebody asked me in the past lectures also that when are we going to discuss about the raised age bar for marriages of girls in India. So this is what we are up with today, the Prohibition of Child Marriage Amendment Bill 2021. So, the Child Marriage Prohibition and Regulation Act of 1986. There's one, there are some laws that prohibit child marriage. Child marriage is one of those taboos and one of those evil practices which have been practiced in the ancient, in the ancient Indian society, and which continue to dominate the Indian society's belief and faith up till now, even up to the 20th century. And you can also find this practice in various pockets of India even today. So this child marriage, like we had, this occupies a place in all those evil practices which were considered despicable and deplorable, like sati pratha, like dowry. Even today we can see these kinds of things being practiced, like child marriage. Okay, child marriage is also one of those taboos which have been calibratedly attacked and targeted by various legislations in India. And by the efforts of these legislations and laws, the child marriage has been made a punishable offense. Now, earlier, the age of marriage, like according to the Indian Majority Act, when a person becomes major, a person becomes major at the age of 18 years. Okay, according to the Indian Majority Act. The Prohibition of Child Marriage Amendment Bill to 2021, however, the Prohibition of Child Marriage Act, however, fixed the marriage age at 18 for boys, 18 for girls and 21 for boys. But the Prohibition of Child Marriage Amendment Bill 2021 has now raised this marriage age for females from 18 to 21 in India. Okay, from 18 to 21 in India. So the new Child Marriage Amendment Bill was introduced in the Lok Sabha on 20th December 2021. I hope you are able to read the PDF doc behind me on the screen. The Child Marriage Amendment Bill was introduced in the Lok Sabha on 20th December 2021. The primary objective of this bill is to raise the legal marriage age for females from 18 to 21. See, I have highlighted this text from 18 to 21 in India because this has come under serious discussions that why this marriage age for females has been raised, because some are in favor of this while some are against this. The justification behind this amendment is the enforcement of the constitutional mandate of gender equality, as the legal marriage age for males in India is 21. Like the Constitution of India, under Article 14 also talks about right to equality. What does Article 14 says? right to equality. The state shall not deny to any person equality before law or the equal protection of laws. Similarly, we have these rights up to Article 18. Okay. The act has uniform application. Yes, uniform application in the sense like it applies uniformly throughout the length and breadth of the country. Yes. Okay. So the justification behind this amendment is the enforcement of the constitutional mandate of gender equality, as the legal marriage age for males in India is 21. So this 21 age has been raised and has been brought at par with the marriage age for boys because of the enforcement of the constitutional mandate of gender equality. So I was talking about Article 14. Article 14 to 18, they all talk about equality. Article 14, however, talks in general terms, while Article 15, 16, 17 and 18 talk in particular terms. But, however, all these articles talk about one and the same thing, the establishment of equality in the society. Okay. So this enforcement of the constitutional mandate of gender equality was done by raising the marriage age bar for females in India from 18 to 21. Okay, because the boys marriage age is 21. So why should girls be allowed to marry at 18? Why shouldn't be there the gender equality so far as the marriage age for both boys and girls is concerned? Okay, right? Because we have fundamental rights on equality, gender equality. We have so many directive principles of a state policy. Okay. There's one question. I mean, in different personal laws, the act has uniform application in different personal laws. Yes, they're different personal laws. Obviously, the act has different personal laws. Don't say different personal laws. Different personal laws have their own applications. But different personal laws are not allowed. Like this child Prohibition of Child Marriage Act is the act that deals uniformly across all the sections of the population and across all the sections of the citizenry, irrespective of any caste, creed, religion or sex. Okay. Then there is okay, so allow me to complete one answer. Jazbat is asking that is there a uniform application of Prohibition of Child Marriage Act in different personal laws? Yes, different personal laws में देखिए, अब जैसे for example Muslim personal law में a person can marry as soon as he or she attains puberty. Like if the girls, they attain maturity at the age of 13, 14 or 15, like the same way boys attain the age of 14, 15, 16, 17. So in Islam, in the Muslim law, they are allowed to get married. Okay. So we do not have this provision in India. We have personal laws application. The personal laws are uniformly applicable across India, across the length and breadth of the country, but we do not have certain provisions are not applicable, or certain provisions of the personal laws are not applicable. This child marriage amendment bill was this Prohibition of Child Marriage Act, I'm sorry, is the law which applies uniformly to all sections of the population, irrespective of any religion. Okay. Then Chitralekha Bhagwati is asking, as a major 18 plus female, it could be my own choice to be married by 20 years. It is my right to marry the person of my choice at the age of my choice. How can choice as a major adult be regulated? We are not talking about choice. We have already talked about it in the Supreme Court judgment in the Shafin Jahan versus Ashokan KM case. We already talked about it. Obviously, as a major, you have full right to marry a person of your own choice. That's the ruling of the Supreme Court. That's the finding of the Supreme Court, and that is a matter of right. Under Article 21 of the Constitution of India, you have the right to marry a person of your own choice. But right now we are not discussing about choice. We are discussing about the marriage age, because the marriage age for boys in India is 21. Earlier, for the marriage age for females was 18, but this Child Marriage Amendment Bill 2021 has amended the Prohibition of Child Marriage Act and has raised the legal marriage age bar for females from 18 to 21 in order to enforce the constitutional mandate of gender equality. Okay. Then Ba Jazbat is asking that Muslim marriage being a contract has to be in accordance with essentials of a contract. Yes, it has to be in accordance with the essentials of a contract. Marriage in Muslim law is more like a contract. You might have gone through all these cases of Justice Mahmood on this issue. Then you are going to ask that who is a major according to the contract in Islam. There is no, 18 is not the age for calling a person a major. Any person who has attained puberty, who has come of age of puberty, is major. And as a major, he is allowed to enter into that contract. Okay. Are you getting my point? So Chitralekha, we are not talking about choice. We are talking about the marriage age. Okay. Got it? Now the following key amendments have been made in the Prohibition of Child Marriage Act. Let us look at the provisions of the Prohibition of Child Marriage Amendment Bill 2021. What sort of changes it has made in the existing law. Okay. Section 2 of the Child Marriage Act, under which child now refers to any male or female who has not attained the age of 21 years, notwithstanding any such law or customary practice opposed to this amendment. Okay. Then there is another question. That means Indian Majority Act does not apply then. Who said Indian Majority Act does not apply? Indian Majority Act applies, but Muslim law does not apply. The application of Muslim law is restricted to certain things only, like marriage, divorce. The procedure for marriage, the procedure for divorce are recognized by the Indian courts and Indian law of the land. The procedure for nikah, the procedure for talaq in Muslim law are already recognized by the law of the land, law of the country. Okay. So, but so far as the majority issue is concerned, only Indian Majority Act is applicable across all the sections of the population, irrespective of any religion. A Muslim boy would be called a major in India only when he attains the age of 18 years, not when he attains puberty. Because in this respect, Muslim law is not applicable. Okay, a Muslim boy as an Indian citizen would be covered by the Indian Majority Act. Okay. So who said Indian Majority Act is not applicable? Indian Majority Act is applicable. Any person who tries to get their children married below the age of 18 years would have to face the music, would have to face the punishment and liability, because that is an offense. Okay. The marriage age fixed by the law has to be followed. That's it. Okay. Then Chitralekha again is asking, age of my marriage is also my choice as a major female. No, the issue regarding age is different. The issue regarding age, Chitralekha, is a different topic, is a different thing. You have a choice to marry the person of your own choice. You have that liberty and freedom to marry the person of your own choice. But you do not have this freedom and liberty to decide at what age you are going to marry, because these ages have been fixed in accordance with the biological maturity a person attains. You know, the law has been designed in a way so that any person who gets married would be able to bear the pains of marriage also. You are not getting my point. This is a serious issue. Marriage is a serious issue. Don't take it lightly. Will a girl below the age of 18 years, or a person 18, or a girl 18 of 18 years of age, if she is weak enough, will she be able to bear the child in her womb? Sometimes, most of the time, and in most of the cases, it has happened that young girls have been made pregnant, and they were not able to bear the child because of excessive weakness and because of their tender age. So this is a serious issue. We have to raise the marriage age for females in India. This can be one of the issues that can be contended in favor of the legislation, in favor of the amendment. Okay, are you getting my point? That has to be looked into. You have the choice, but these biological things, biological concepts and phenomena and natural phenomena are also necessary to be reckoned with or taken into account. Okay, because it is about the general health of the women in India. Okay, so we started reading this the key amendments made in the Prohibition of Child Marriage Act. Section 2 of the Child Marriage Act, under which child now refers to any male or female who has not attained the age of 21 years, notwithstanding any such law or customary practice opposed to this amendment. Section 2 of the Child Marriage Act. Section 2 of the Child Marriage Act, under which child now refers to any male or female who has not attained the age of 21 years, notwithstanding any such law or customary practice opposed to this amendment. Now, if a male child was any person, any child below the age of 21 years was considered a child. For girls, any girl under the age of 18 years was considered a child. But now girls also up to the age of 21 years would be considered as a child like boys. So section 2 of the Child Marriage Act, under which child now refers to any male or female who has not attained the age of 21 years, notwithstanding any such law or customary practice opposed to this amendment. देखिए बात जज्बात और तुम यूवर आस्किंग कि यहां पर कौन सा इसका यूनिफॉर्म एप्लीकेशन है कि नहीं. यहां पर आपने ये पढ़ा सेक्शन 2 में क्या लिखा हुआ है. 21 इयर्स के बाद देखिए, 21 इयर्स के बाद देखिए यहां लिखा हुआ है नॉट विद स्टैंडिंग एनी सच लॉ और कस्टमरी प्रैक्टिस. चाहे कोई भी लॉ या कस्टमरी प्रैक्टिस हो जहां पर लड़के लड़कियों की शादी जल्दी कर दी जाती हो, उससे कोई फर्क नहीं पड़ता. नॉट विद स्टैंडिंग का मतलब है कि उनका इफेक्ट नल एंड वॉइड हो चुका है. जो इस सेक्शन में कहा जा रहा है वही अप्लाई होगा. ये नॉन ऑब्स्टेंट क्लॉज है. दीज नॉट विद स्टैंडिंग से जो शुरू होते हैं या जिन क्लॉजेस के अंदर नॉट विद स्टैंडिंग लिखा होता है, इसका मतलब यह कि हालांकि किसी भी लॉ में कुछ भी लिखा हो, लेकिन 21 साल से कम का लड़का या लड़की दोनों चाइल्ड समझे जाएंगे. ओके, बात समझ में आ गई. सो आई एम रीडिंग इट अगेन. Section 2 of the Child Marriage Act, under which child now refers to any male or female who has not attained the age of 21 years, notwithstanding any such law or customary practice opposed to this amendment. Anaka is asking, it's like fixing a legal age for drinking. If you want, you can drink at 15. That doesn't make it legal. Like drinking is an issue like, I mean, I'm not able to connect the two dots. How can this drinking, the act of drinking, can be compared to marriage? That doesn't make it legal. It is legal in some states. Drinking is legal in some states. It is a state subject. Gujarat has prohibited it. Okay. Drink and drive is an offense, but simply sitting and drinking in your own place, in your own private space, is legal in Uttar Pradesh. Okay. If you want, you can drink at 15. Obviously, you can drink at 15 in some states. What are you trying to ask? Clear your question first. Okay, it was an answer to this question. It's like fixing a legal age for drinking. If you want, you can drink at 15. That doesn't make it legal. Okay, fine. Fine. Okay. Section 2 of the Child Marriage Act, under which child now refers to any male or female who has not attained the age of 21 years, notwithstanding any such law or customary practice opposed to this amendment. Now, substitution of the words 2 years. What is the next amendment? The substitution of the words 2 years with 5 years in section 3, subsection 3 of the Act, which deals with the child filing a petition for the annulment of child marriage. Post this amendment, a child may file such a petition only before completing 5 years of attaining majority. Okay. Now, substitution of the words. The next amendment is made in section 3, subsection 3, which deals with the child filing a petition for the annulment of child marriage. Post this amendment, a child may file such a petition only before completing 5 years of attaining majority. Only before completing 5 years of attaining majority. Okay. Now, have you understood this paragraph? पहले 2 साल, ठीक है, पहले 5 साल, पहले 2 साल था जिसको सब्स्टिट्यूट कर दिया गया 5 साल से सेक्शन 3 सबसेक्शन 3 में ऑफ द एक्ट, जिसमें ये डील किया जा रहा है कि एक चाइल्ड जिसकी चाइल्ड मैरिज की गई है, इफ he or she wants to file a petition for the annulment of child marriage, can file it only before completing 2 years of attaining majority. Okay, but now he or she is legally competent under section 3 of subsection 3 to file it even before completing 5 years of attaining majority to get his or her child marriage annulled. Okay, are you getting my point now? Substitution of the words 2 years with 5 years in section 3 subsection 3 of the act, which deals with the child filing a petition for the annulment of child marriage. Post this amendment, a child may file such a petition only before completing 5 years of attaining majority. 5 years of attaining majority. Post this amendment. इस amendment के आने के बाद a child may file such a petition only before completing 5 years of attaining majority. 5 साल पहले ही उसको competent कर दिया कि if he or she wants to get his marriage annulled, can do so even before completing 5 years of attaining majority. ठीक है, उसको बढ़ा दिया है टाइम पीरियड को, टाइम पीरियड को बढ़ा दिया है. पहले 2 साल था, अब 2 साल में बात नहीं समझ में आती हो, 2 साल बाद तक 2 साल तक आपने मेजॉरिटी अटेन. Yes, it is setting limitation for 5 years exactly. मेजॉरिटी अटेन की, 18 के हो गए, 21 के हो गए मान लीजिए, 18 के हो गए मान लीजिए। फॉर एग्जांपल एक लड़की का केस है, 18 साल की हो गई, वो मेजर हो गई, उसकी चाइल्ड मैरिज हुई है, तो वो 18 साल से जिस दिन की हुई है उस दिन से 2 साल तक का टाइम लिमिटेशन था उसके पास। अगर वो चाहे तो अपनी मैरिज को एनल करवा सकती है पिटीशन फाइल करके। पिटीशन फाइल करने का लिमिटेशन क्या था, है ना, 2 साल। 2 साल में हो सकता है कि वो ना समझ पाए कि मेरी शादी सही है कि नहीं है, इफ शी वॉन्ट्स टू कंटिन्यू और शी वॉन्ट्स टू डिसकंटिन्यू। तो वो जो टाइम पीरियड था, वो जो लिमिटेशन था 2 साल का, उसको बढ़ा दिया गया है। अब उसके पास 5 साल है डिसाइड करने के लिए। Like up to now 5 years, for the next 5 years she can still be competent to file a petition for the annulment of her marriage. Okay, 5 years. He should have to keep silent. Who has to keep silence? Majority is 18 in this case. Majority now is 21. Now majority is 21 after this amendment. Okay, I am giving an example. पहला वाला कि जब 18 थी एज लड़कियों की, 2 साल तक का पीरियड था, अब तो मैरिज एज भी बढ़ा दी गई है, मेजॉरिटी भी बढ़ा दी गई है और लिमिटेशन भी बढ़ा दिया गया है 5 साल का। ओके, अब आ गई बात समझ में। Now insertion of section 14A, a new section has been inserted in the act which states that these new amendments, now it is 5 years from 18, now it is 5 years from 21 also. You can take 21 as the new age, because हमने यहां क्या पढ़ा था चित्रलेखा, हमने यहां क्या पढ़ा सेक्शन 2 में, सेक्शन 2 में हमने पढ़ा कि जो चाइल्ड है वो 21 साल से कम का लड़का हो या लड़की, नए अमेंडमेंट में, ठीक है, नए अमेंडमेंट में जो लड़का है मेल या फीमेल है 21 साल, तो टेक 21 years. ओके, Astha is asking 5 years before attaining majority or after that? Obviously 5 years after attaining majority and before the completion of those 5 years. अरे भाई कंप्लीट कब हो रहे हैं 5 years? 21 साल से अगर 5 साल लगाएंगे आप तो 22, 23, 24, 25, 26, 26वां साल पूरा करने से पहले पहले अगर पिटीशन फाइल करना है तो कर दें, बात खत्म। 5 years का जो गैप है वो खत्म नहीं होना चाहिए। 5 साल खत्म हो गए, उसके बाद ध्यान आ रहा है कि हमें चाइल्ड मैरिज अपनी एनल करनी है, लिमिटेशन इज ओवर नाउ। ठीक है, समझ गई आस्था? यस, एज ऑफ मेजॉरिटी विद रिगार्ड टू मैरिज इज नाउ 21। ये अब कॉन्ट्रैक्ट में मत लिखाइएगा, लॉ ऑफ कॉन्ट्रैक्ट में 21 नहीं है, वो 18 ही रहेगी। कॉमर्शियल ट्रांजैक्शंस के लिए, हर चीज के लिए एज ऑफ मेजॉरिटी अंडर द इंडियन मेजॉरिटी एक्ट के हिसाब से ही होगा। यहां सिर्फ पर्टिकुलरली हम मैरिज की बात कर रहे हैं। Yes, Chitralekha, it can be taken as 5 years from 21. It can be taken as 5 years from 21 now. After this amendment of 2021, this Prohibition of Child Marriage Amendment Bill 2021, after this amendment, it can be taken 5 years from 21. Because we are particularly talking about the age of marriage. We are not talking about any other transaction. Because Indian Majority Act continues to keep the age of majority at 18 only. So a person becomes major at 18 only, whether male or female. But with regard to marriage, the marriage age has been raised from 18 to 21 for girls. It was already 21 for boys, and to enforce the constitutional mandate of gender equality, this has been raised from 18 to 21. That's it. This annulment provision is for females only. Both of them are competent to do that. Okay, don't leave boys behind. Boys are equally competent to do that. If boys are not finding the marriage good enough, they can get it discontinued or annulled by filing a petition within 5 years of their age of majority, from before the completion of 5 years from the age of majority. Okay. No, before attaining majority नहीं है अंकिता, ठीक है? Before attaining majority नहीं है. After attaining majority, before the completion of 5 years. After attaining majority, before completion of 5 years. एज ऑफ मेजॉरिटी से 5 साल काउंट डाउन शुरू हो जाएगा, 5 साल का. तो जब ये 5 साल का काउंट डाउन खत्म होने से पहले पिटिशन फाइल कर दीजिए, ठीक है? Yes, Ankita, can be taken. 5 years from 21 can be taken. Insertion of 14A in the Act states that these new amendments will have an overriding effect in context to the existing laws or customs that may contradict the amendments. Okay? एक नया सेक्शन इंसर्ट किया गया है, सेक्शन 14 कैपिटल A, which states that these new amendments will have an overriding effect in context to the existing laws or customs that may contradict the amendments. If we have any existing law, if we have any custom that necessitates or validates the marriage of a person below the age of 21 years, then that will be invalid so far as the application of this amendment is concerned, because this amendment is going to have an overriding effect in context to all those existing laws or customs that may contradict the amendments. Anything, any law or any custom that contradicts the amendments that allows the marriage below the age of 21 years of either male or female will not stand valid in front of this new amendment of 2021, because this new amendment of 2021 shall have an overriding effect in context to all those existing laws or customs that may contradict the amendments. So this new section 14A has been deliberately and intentionally inserted in the act so that it can, this new amendment can have the power to override the effects of all the other existing laws or customs that may contradict the amendment. Are you getting my point? Yes, Aman Soni, child covers both male and female after attaining majority. Yes, obviously. क्या मतलब मेल जो है वो बच्चा नहीं होता है कभी, दोनों ही तो बच्चे होंगे, दोनों की बात की जा रही है, खाली लड़की की बात थोड़ी की जा रही है. अब आप देखिए, ये बात जज्बात और तुम जो थे ये बहुत देर से पूछ रही हैं कि ये बहुत सारे पर्सनल लॉज हैं जहां पर जिनसे ये कॉन्ट्रडिक्ट कर रहा है, ठीक है? सेक्शन 14A में इसका आंसर है. सेक्शन 14A की पूरी बात समझ में आ गई है आप लोगों के कि इसका ये जो अमेंडमेंट है इसका ओवरराइडिंग इफेक्ट रहेगा बाकी सारे एग्जिस्टिंग लॉज और कस्टम्स पे दैट में कॉन्ट्रडिक्ट द अमेंडमेंट्स. द अदर पर्सनल एंड मैरिज लॉज सच एज द हिंदू मैरिज एक्ट, हिंदू माइनॉरिटी एंड गार्डियनशिप एक्ट and the Foreign Marriage Act, Indian Christian Marriage Act, Parsi Marriage Act, Divorce Act, Muslim Personal Law or Shariat Application Act and the Special Marriage Act shall be amended accordingly to be consistent with these new provisions. Like we have so many personal laws today. Like there's a list of personal laws before us right now. अंकिता क्या कहना चाह रही है? मेल की शादी नहीं होती, मेल की शादी नहीं होती तो फीमेल की फिर किससे होती है? ये बताइए, इन मोस्ट केसेस व्हाट? मेल की शादी नहीं होती, इससे क्या मतलब है आपका? अच्छा, यू वर आंसरिंग मेल की शादी नहीं होती, किस बात का जवाब है ये? Okay, so we have a list of personal laws. These personal laws might allow the marriage of persons below the age of 21 years, either male or female. So all these personal laws are going to be amended very soon in order to be consistent with this new amendment. Okay. In order to be consistent with this new amendment, this is going to be like they are going to be amended very soon. Okay. अब आपको इस बात का जवाब मिल गया होगा कि इतने सारे हमारे यहाँ पर्सनल लॉज हैं, तो इतने सारे हमारे यहाँ पर्सनल लॉज हैं, तो ये पर्सनल लॉज जो हैं अच्छा, अंकिता was trying to say before majority. अंकिता was trying to say before majority. Before majority तो लड़की की भी नहीं होनी चाहिए थी, और बहुत सारे केसेस में लड़कों की भी मेल की भी शादी बिफोर मेजॉरिटी हुई है. चाइल्ड मैरिज में यही तो होता था, अकेली लड़की की शादी तो होती नहीं थी, लड़के के साथ ही तो होती थी, उसकी तो लड़का भी तो बच्चा ही होता था. मोस्ट ऑफ द केसेस में बहुत कम ऐसा होता था कि बॉय यूज्ड टू बी वेरी एज्ड. ओके. Prableen is asking, but customs always prevails over law. Customs, no. There are ample of customs which have been overridden by the legislations, by the new legislations. Okay, which have been overridden. While some of the customs which found consonance with the existing laws of the country and also the Constitution of India were given a constitutional mandate and a legal mandate. They attained legal attestation and they were so recognized by the law. But hardly, you cannot say that the customs prevail over law. Only law prevails. There is a rule of law in the country. Okay. Now, all these, I was saying that the section 14A has been inserted in the act, which states that these new amendments will have an overriding effect in context to the existing laws or customs that may contradict the amendments. The other personal and marriage laws, such as the Hindu Marriage Act, Hindu Minority and Guardianship Act, and the Foreign Marriage Act, Indian Christian Marriage Act, Parsi Marriage and Divorce Act, Muslim Personal Law, Application Act, and the Special Marriage Act shall be amended accordingly to be consistent with these new provisions. This legislation will be implemented 2 years after the President's approval. Now, this legislation, this amendment legislation will be implemented 2 years after the President's approval. The President is going to approve it when he is going to sign this bill. Only after 2 years of his signing, this is going to be implemented. Union Women and Child Development Minister Smriti Irani introduced this bill, stating that it will be applicable to all castes and religions. All castes and religions. Yes, Ankita, you are right. ठीक है. Ankita, you are right. Custom should be moral. Custom should be moral, and also it should find some consonance with the Constitution of India and the law of the land. Only then it can, any usage can attain a legal attestation, and only then that usage can become a custom. Okay. So I was reading this, that Union Women and Child Development Minister Smriti Irani introduced this bill, stating that it will be applicable to all castes and religions. This act itself upholds the principles of the fundamental right to equality by keeping the marriage age 21 years for both male and female citizens. Okay. I told you that this is trying to enforce the constitutional mandate of gender equality. We are talking about right to equality. We have talked about gender equality a lot in our conferences, in our law schools and courts and the judiciary, and in the courtrooms. We have discussed it a lot. Now, when are we going to enforce it? We are going to enforce it through these things, like this act itself upholds the principle of the fundamental right to equality by keeping the marriage age 21 years for both male and female citizens. This will widen educational and occupational opportunities for women, as it will give them more time to receive education or engage themselves in work aspects, as such common privileges are denied to a large percentage of women post marriage. Okay, like why should always women get married at so early than the boys? And because of this early age of marriage of girls, they are quite often denied certain privileges and certain benefits. They are denied employment opportunities, and fast emerging careers of these girls gets ruined or spoiled. Okay, so this act itself upholds the principles of the fundamental right to equality by keeping the marriage age 21 years for both male and female citizens. This will widen educational and occupational opportunities for women, as it will give them more time to receive education. At least 18 साल पे अगर कोई लड़की हाई स्कूल करती है तो at least she can complete her graduation. It's not that as soon as she attains the age of 18 years, she's going to get married and only she high school के बाद वो पढ़ ही ना पाए. ऐसा नहीं होगा. So this will widen educational and occupational opportunities for women, as it will give them more time to receive education. Because बहुत सारे conservative mindsets में, बहुत सारी conservative families में, जहाँ पर India especially typical ancient families या mindsets के साथ जो आज भी लोग रह रहे हैं, they don't want women to study after marriage. They want her to look after the household chores. So this will not happen now. At least this will widen educational and occupational opportunities. At least she can complete her graduation studies up to the age of 21. Okay. This means it has prospective effect. Yes, exactly. It has prospective effect. It has prospective effect. Okay. This will widen educational and occupational opportunities for women, as it will give them more time to receive education or engage themselves in work aspects, as such common privileges are denied to a large percentage of women post-marriage. In such situations, men become the sole providers of the household, and their wives are forced to rely on their earning husbands for financial support. Men become the sole providers of the household, and their wives are forced to rely on their earning husbands for financial support. Okay. Now, in addition to this, empowering women by improving their nutrition levels and lowering the maternal mortality rate was another bill. Okay. Empowering women. What is the object behind bringing this legislation? मकसद क्या है? Empowering women by improving their nutrition levels. At least they would get extra 3 years. They are getting extra 3 years by virtue of this law. So they are going to get like more physically strong. They are going to have higher nutrition levels, at least at the time when they get married. This will lower the maternal mortality rate, because in most of the cases girls have been married at the tender ages. They become pregnant, and there is higher maternal mortality rate, because most of the girls, they die during pregnancy. They die while delivering the child, because their nutrition levels are quite low, or they are physically weak. They are physically too weak and too feeble to bear the child in their wombs. So this would lower the maternal mortality rate. Okay. This would empower women by improving their nutrition levels. So at least they are getting extra 3 years to work upon themselves. Right. According to a demographic study by the National Library of Medicine, the maternal mortality in 2020 alone was 23,800 deaths. 63% of deaths occurred in rural areas. This happens mostly in rural areas because of a bunch of reasons. because people in rural areas want to get their daughters married at a very tender age. Okay, they don't even follow the law of 18 years. They were not even following the law of 18 years. They want them to get married as and when she attains puberty. Okay, so they want to get them married, and in most of the cases these girls have got married because of excessive compulsion of their parents, because their parents have forced them into marital bonds. They were made pregnant by their husbands, and they had faced, like, they finally died during pregnancy or while delivering the child, because they were too weak to bear the child. They were too immature to bear the pains of, like, to bear the labor pains, or to bear the pains of delivering the child. Okay, so like 63% graph is much, is worrisome. 63% of deaths occurred in rural areas. Moreover, evidence from a study by Anne Blank showed that women after the age of 18 are proven to be comparatively healthier and more nourished, which naturally decreases the maternal mortality rate. I mean, this is very simple. You can read the paragraph and understand what does this means. Okay. However, one cannot turn a blind eye to some offsetting factors about this act. Since this bill has overriding properties, it will completely nullify the provisions mentioned in the various personal and marriage laws regarding the age of marriage. Now, baat to tum was asking about what about the enforcement of those laws which allow marriages and the personal laws. You were asking about the uniform application in various personal laws, na? Uniform application of this law, while we have various personal laws which allow the age of marriage at a very young age, See, your concern will be addressed here. Yes, this will become law after 2 years. Yes, obviously, Ankita, this bill will become law after 2 years only. That's right. Okay. However, one cannot turn a blind eye to some offsetting factors about this act. Since this bill has overriding properties, it will completely nullify the provisions mentioned in the various personal and marriage laws regarding the age of marriage. For example, the age of marriage for females is 18 years and 21 for males under Section 5(3) of the Hindu Marriage Act 1955. Yes, Ankita, this is going to become, this bill will going to be enforced after 2 years only. Okay. So, अब वेरियस पर्सनल और मैरिज लॉज में क्या है, एज ऑफ मैरिज डिफरेंट है, और यहां पर जो ये लॉ फिक्स कर रहा है ये डिफरेंट है. सो द एज ऑफ मैरिज फॉर फीमेल्स इज 18 years and 21 years for males under Section 5(3) of the Hindu Marriage Act 1955. This new amendment, this new Prohibition of Child Marriage Amendment Bill 2021 will nullify this particular provision and mandate the minimum age of 21 years for both male and female, दोनों के लिए. अब पर्सनल लॉज में जहां पर कम एज लिखी हुई है डिफरेंट पर्सनल लॉज में, उन सारे लॉज को भी अमेंड कर दिया जाएगा to bring them in consonance and in conformity with this new Prohibition of Child Marriage Amendment Bill 2021. Okay, on a closer look at the bigger picture, it can be observed that this bill is another stepping stone for BJP on the path to Uniform Civil Code or UCC. We will discuss Uniform Civil Code in some other week. In the upcoming week, this upcoming week, we shall be discussing some judgment summaries, and the next week of this upcoming week, we shall be discussing certain legal issues, current legal issues. So we are going to take Uniform Civil Code as one of the topics. Uniform Civil Code was always a current topic and shall always be current topic unless and until it is enforced, because there are some latest developments. We are slowly heading towards uniform civil code. It is like keeping away all the personal laws and putting them at bay, and getting a uniform civil codes and uniform civil laws for all the citizenry, for all the sections of the citizenry. So we are slowly heading towards uniform civil code. This is like if you are amending the personal laws to bring them in conformity and in consonance with this new prohibition of child marriage amendment bill 2021. This is like a general law. This is not a personal law. So if all the personal laws are being brought in conformity with this new amendment bill of 2021, then obviously the personal laws will lose their own nature. The very own nature of the personal laws will be lost. And this is going to be a step towards the application or enforcement of the Uniform Civil Code. Okay. While the concept of UCC itself is an excellent idea, as uniformity in legal rules can lead to speedy trials and clarity of laws, its application is not viable in India due to its vast diversity as well as its rich history of traditions. Okay. Like there's some interviews also of various political faces. Like this is one of the national executive of the Rashtriya Swam Sevak Sangh. UCC is good for the country and there are several judgments on the need for it. On the contrary, according to the Law Commission's 2018 report on the feasibility of UCC and reform of family law as demanded by this government in 2016, discriminatory personal laws may be removed or amended, but UCC in India is neither necessary nor desirable at this stage. The author of this article is trying to prove, that UCC is neither necessary nor desirable. You can remove certain, objectionable and discriminatory provisions from various personal laws either by removing them permanently, deleting them permanently, or amending or modifying them in a way so that they may fall in consonance with the existing laws of the country. But it is not desirable, it is neither necessary nor desirable to bring UCC in place and put all the personal laws completely all together at bay. That is not needed. Okay. Chitralekha Bhagwati is again exactly, I was thinking how one thing after another is leading us to UCC. Okay, yes, that's how we are slowly heading towards UCC. But right now I don't want to, initiate this new discussion on UCC because it's a very vast topic and we are going to discuss it in the upcoming weeks. Therefore, such reforms in personal laws could lead to serious legal implications and mass instability as a result of the clash between the validity of the pre-existing personal laws and the newly formed uniform law. The most significant issue arises with Muslim personal law. It is quite difficult to establish harmony between the new amendment and the provisions of this law in context with the marriage age, as the Muslim law states that a girl can be married once she attains puberty. Like there is a lot of contradiction between the personal laws, especially Muslim personal law, because it mandates the marriage of a girl as soon as she attains puberty, while this amendment is fixing the marriage age as 21. Okay, this age is usually taken to be 15 years. Like on an average, it can be taken 15 years in Muslim law that a girl attains puberty at the age of some attain like at 13, some of them attain at 15, some of them attain at 14, like some of them attain at 10, 11 or 12. So if we take out an average, it's usually 15 years. However, as the Muslim personal law is a codification of the Sharia law, the question of legislations and judiciary's extent of jurisdiction over divine or religious laws arises. Okay. However, as the Muslim personal law is a codification of the Sharia law, the question of the legislations and judiciary's extent of jurisdiction over divine or religious laws arises. The Apex Court has stated that all personal laws must follow the principles and regulations of the Constitution, but several high courts have varied opinions on this matter. Okay. The Apex Court had stated that all personal laws must follow the principles and regulations of the Constitution, but several high courts have varied opinions on this matter. Okay. The most striking fact about this bill is that no amendments were made for child marriage in the bill. The Prohibition of Child Marriage Amendment Act 2021 has no provisions to make child marriage void. Under the current legal regulations as stated in section 3(1), child marriage is voidable at the option of the underage party to marriage within 2 years of attaining maturity. Okay, so what is the difference between void and voidable? Void is completely like does not have any legal standing, does not have any legal identity or legal attestation. That is void. The law does not recognize something, and that which is not recognized anything by law is void. And what is voidable? What is voidable? Voidable is simply that when it can be nullified, when a contract or a marriage can be nullified at the option of one party. So under this new Prohibition of Child Marriage Amendment Act 2021, this is not making child marriage void. This is simply making it voidable at the option of the underage party within 2 years of attaining maturity. With this 2 years has now been amended to 5 years. Okay. अब ये 2 साल की जगह 5 साल कर दिया है. ठीक है, सेक्शन 3 में. Are you getting my point? Voidable थी ना मैरिज. किसी की शादी 16 साल में हो गई, लड़का जो है वो 22 साल का है या 21 साल का है. He has completed 21 years of age. ठीक है, he has completed 21 years of age. So like 16 वाले के पार्ट पर ये voidable होगी. 16 वाला कौन है? यहाँ पे लड़की है. लड़की के ऑप्शन पे ये voidable होगी कब? As and when she becomes 18 years older. जब वो 18 साल की हो जाएगी. लेकिन अब ये एज 21 की हो गई है. ठीक है, और 21 से फिर voidable का ऑप्शन कब तक एक्सरसाइज कर सकती है? वो 2 साल तक नहीं, 5 साल तक कर सकती है. ठीक है, 5 साल तक कर सकती है. However, as noted by the Center for Law and Research Policy brief, the provisions of the current law put an encumbrance on the child to annul the child marriage within a limited time period. Moreover, the child usually faces several impediments while seeking an annulment, like lack of familiar support, societal pressure, the threat of violence, and financial constraints. Due to a lack of awareness about their rights, children are often prevented from reaching out to NGOs or child marriage prohibition officers. It also causes a hindrance in the education and career growth of these girls. Child marriages also lead to sexual abuse of kids and early pregnancies, posing serious health risks to both the mother and baby. According to the National Family Health Survey of 2016, the under 5 mortality rate was 59.2% among women who gave birth under the age of 20 years. Government officials have intervened in more than 5,584 child marriages in 2021 alone. Respected retired judges M.B. Lokur and Deepak Gupta have deemed it strange that child marriages in India are illegal but not void. Okay, the intended progressive goal of this amendment with regard to women empowerment must be reflected in the main reason for the formation of this child marriage legislation. Although this amendment to raise the marriage age to 21 years is very fruitful in theory, as it allows for better education prospects for women and better nutrition levels, it will have only a little impact on society. Like, this is a very simple language. You can understand the nuances of the and implications, the consequences, the merits and the demerits of the child marriage. Like, everything has been discussed here thoroughly. The women who are most likely to benefit from increased education and career opportunities come from advantaged families that support this. However, women from rural sectors or from low castes would rarely be able to avail these benefits due to a lack of awareness about their rights and minimal legal or family support. Awareness campaigns, especially in rural regions, are needed to make some real change. Who is going to do that? Obviously, you or me, who are like the lawyers, The law students are supposed to do this, like go out, meet people, interact with the different sections in the rural areas and aware them, make them aware of their rights. Do this, don't wait for anybody. It is your and mine responsibility to do that. We have to get them educated. Like it is about not only about simply about a marriage age, it is also about the legal rights, their health, their family, their lives. Okay. So awareness campaigns, especially in rural regions, are needed to make some real change. Therefore, the focus should be laid on stricter implementation of laws, as structural changes within the government system and society are needed rather than such legislations to promote actual women empowerment. Okay, so that's all about today's topic. Now, if you have any query, you're most welcome to ask. Okay, thank you, Chitralekha, and thank you all. I guess no more questions are there. Go through the PDF doc, and I wish you all the best. All the very best. Do well and stay safe at home. See you tomorrow. Bye bye.